Hello and welcome to another view from Mayor Brown. This sits alongside our regular podcast and is an occasional series of interviews with those involved in the changes going on in employment law. The podcast is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to this special podcast on Brexit. I'm Nick Robertson of Mayor Brown's London employment team and one of the firm's global practice group leaders of the Employment and Benefits Group, and I'm delighted to be joined by my fellow partner.
My name is Mark Prinsley and I'm head of the Intellectual Property and Information Technology practice in the London office. Our practice encompasses all areas of intellectual property and data privacy. And for the purposes of today's podcast, I'd like to focus on the data privacy aspects of the UK's decision to Brexit.
So, just picking up, both of us do regular podcast series, and the background to this was that we were talking the other day about work which we're both doing in connection with Brexit, and it struck us that there was a certain amount of overlap between the work that we're doing for employers, and also there are some areas that are specific to each of us. But we thought it'd be a really good idea to do a joint podcast to share the knowledge and also to indicate that there are some common issues, common steps that businesses should be thinking about. But before we do that, Mark, do you want to say anything about the podcast series that you do on a regular basis?
Yes, we'd be delighted to do that. Our podcast series is, in fact, a series of episodes we're releasing on a YouTube channel called CL-IPS, which is aimed at demystifying some of the arcane areas of intellectual property to the YouTube community. So episodes that we have released recently include an attempt to demystify the rules around fair use, and another episode on the use of open source code in programming. And we are engaging with the YouTube community in a way which is new for a law firm such as ourselves.
Okay, and I can certainly say, having seen a number of the YouTube clips, they're great fun and highly informative. Yes, well worth a look. We tend to restrict ourselves to audio podcasts, so we've done an employment podcast series for coming up for 4 years now. We are with Insight of episode number 100 of the fortnightly podcast series, which is predominantly aimed at HR and in-house legal, and picks up on case decisions and so on in the previous fortnight, which are of general importance to employers. Anyway, in terms of the podcast today, what we thought was, frankly, there's been quite a lot of speculation around about what the terms of Britain's exit will look like. Will there be freedom of movement, etc., etc.? And the truth is, of course, no one really knows at this stage. But I don't think it follows from that there's nothing to do at this stage. And we thought it would be productive, and indeed far more productive, to focus on steps that employers, businesses should be taking now in our respective areas, and why they're important. So Mark drew the short straws, so I'm going to go ask Mark to go first, and then I'll pick up afterwards.
That's fine. So as Nick will have advised many employers will be aware of the changes in data privacy law which are due to come into effect in Europe in May 2018, when the General Data Protection Regulation comes into force across the EU. This legislation is primarily aimed at updating data privacy law to take account of the digital world which has emerged since the mid-80s, when data privacy law was last really looked at. Inevitably, as part of this update of data privacy law, there are areas of change which will impact all employers, whatever business they're involved in. So not just businesses which are clearly in the digital world. For example, all businesses will need to be thinking about whether they need to appoint a data privacy officer, reporting to the board, and if so, how they would do that. They'll also need to be thinking about implementing greater transparency in the way they process personal data and the way they describe what they're doing to their community, and also how they implement data minimization so they don't hold on to personal data for longer than they need to do so. In order to create this harmonised law across Europe, the EU decided to implement the legislation by way of a regulation which has direct effect in each member state, rather than by way of a directive which would be adopted into domestic law of each member state. Experience in the data privacy area and in other areas has shown that 28 member states can implement a directive in a dazzlingly different variety of ways. When the UK leaves the EU, EU regulations will cease to apply to the UK, which seems sort of obvious. That would not have been the case if the EU legislation was implemented by way of a directive, because then we would have some UK domestic law. One approach would be to take the view that because the EU data privacy reform is being implemented by way of a regulation, there's no need to bother planning to conform with the regulation, because it's bound to be regarded as bad law and be part of the bonfire of red tape promised by Brexit. I don't think this would be the right approach for at least two reasons. First, the regulation will certainly come into force in May 2018, and even on the most aggressive timetable of the Brexiteers, the UK will not have left the EU by May 2018. So even on a short-term basis, it's going to be the law. Secondly, it's highly likely that the UK will have to adopt measures which are analogous to the regulation in some way, in the event that there is not a simple transition of the EU regulation into UK domestic law. Global business and consumer groups will quite simply demand certainty in this area, and there's no way one could go back to the drawing board on this broad area. I mean, there may be opportunities for businesses to lobby for a slightly more business-friendly approach to data privacy treatment, but in the UK as opposed to via the regulation. But the broad framework is going to have to be the same. So perhaps the most important message for this podcast as far as data privacy is concerned is that the Brexit vote should not blow your business off course in terms of preparing for implementation of the general data privacy regulation.
And presumably, if assuming that businesses are trading with Europe, of operations both in Europe and in the UK, then even if there was a particularly business-friendly regime within Britain, if data is being transferred into Europe, those requirements, those European requirements, will apply.
Yes, I think you're absolutely right to spot the data transfer issue as being the big one. I think that really the question is not so much the data flow out of the UK, but the data flows from mainland Europe or the continental or the EEA to the UK. Under the current system, where the UK is a member of the European Union, personal data can flow freely between each of the member states, and you don't need to bother with any special arrangements. It's just assumed that each member state has an adequate data privacy regime. Where data flows out of the European Union, different rules apply. There are a small number of countries which have what is deemed to be an adequate data protection regime. Those don't include significant countries like the United States and India, but do include Argentina, New Zealand, Jersey and Guernsey. If the transfer is to a country which doesn't have an adequate data protection regime, then the data exporter has to put in place appropriate contractual measures to document that transfer. And those are generally the EU standard contractual clauses or the EU binding corporate rules regime for intra-group transfers. Now, the consequence of Brexit is that the UK's status will change from being in the EU to being outside the EU, and quite possibly outside the European Economic Area as well. So the obvious consequence of that is that unless the UK is deemed by the rest of the EU, or the remaining EU, to be an adequate data protection regime, then businesses moving data from the EU to the UK will need to put in place measures like the standard contractual clauses. Now, it would be quite ideal if the rest of the Europe decided to treat the UK as having an adequate data protection regime, as presumably it does at the moment. But I don't think this can be treated as a foregone conclusion, because the EU has had major difficulty with the transfer of personal data to the United States. And as a result of the Edward Snowden disclosures, we all now know that the UK and the US are part of a intelligence services sharing convention called Five Eyes, under which personal data collected in GCHQ is passed to the NSA in the States. And it would not be completely impossible to imagine continental Europeans taking the view that because of that arrangement, the UK should be treated more like the US than as a former member of the EU, and that transfers from continental Europe to the UK need to be documented by way of standard contractual clauses or binding corporate rules. So what does this mean for employers? Well, employers should be, I think, considering what data is being moved from continental Europe to the UK as part of their general business activities. And employers should certainly be starting to audit those data flows, establishing what data is being moved, and start to think about putting in place the standard contractual clauses. They're not they're not difficult documents, and because they're standard, there's actually very little to vary in them. But each data exporter has to put in place a set of the terms, and if you're a reasonably sizable group with operating businesses in many countries in Europe, sharing data on a group-wide basis, it can be quite time-consuming to do that. Not only should you be looking at the intra-group arrangements, but you should also be looking at arrangements where you move data to third parties. We're not, of course, at all clear what the position is going to be with the UK as far as data privacy is concerned, but let's assume it's broadly a regime like the current EU regime. If you move data out of the UK to the EU or to other countries, you're going to need to document that, and you would need to think about putting the standard contractual clauses in place for your transfers to continental Europe, and also understanding what you're doing with transfers to third parties. And it might be particularly important where you've got a kind of a cloud-based solution. We've been involved in a number of HR solutions where people have used and I think it might be quite common to have these cloud-based tools for hosting global HR data. And it's, I think, important to understand where that data is hosted, because that is going to dictate what measures you need to put in place as an employer outside the EU, but in a freestanding UK.
So in terms of key lessons, there's an auditing in the sense of working out where your data is and your data flows to and from the UK and Europe.
Yes.
And then considering the contractual safeguards route,
yes,
on the assumption that it's very likely that as part of Brexit, the businesses in the UK who are exporting or importing data, personal data, are going to need to have some sort of contractual safeguards in place to ensure that those processes can still continue.
Yes, I think that's right. I think the big difference is that the UK, you're going to have to look at the transfers between the UK and Europe in a different way. It's just a different telescope you have to look at. Whereas before you could be certain that it was adequate and nothing needed to be done now. Well, as in many areas to do with Brexit, there's a degree of uncertainty. But the best thing to do is to at least understand where your data flows are.
Good. Okay. Shall I pick up and talk about the employment bits from there then? Because I think what's interesting is the themes of auditing, analysing, working out what's where, and no longer making assumptions about things that are automatically correct. It's very similar in the HR field doing directly with employees. So, for example, one of the things that we're saying to employers at this stage is that there probably needs to be a people audit. Because if you're a business with employees working in England and Wales, but also working elsewhere in Europe, it's clearly going to be sensible for businesses to take stock of how many employees are where and what the impact might be following the implementation of the Brexit vote. It doesn't necessarily follow that just because someone's working in the UK but they're from France, that they don't have the right to reside in the UK. They may be married to a British national, for example. But it would be entirely appropriate, we think, to ask employees to self-audit, to identify perhaps employees who've got concerns or who may have fears about what their future is post-Brexit. Companies may be concerned that such staff might jump ship. They might leave the UK, or they might go to an employer that is offering to guarantee them some sort of right to remain. So forewarned is forearmed. And we were talking to one client where there was a concern that staff might be spooked if they sent round this sort of self-audit. It doesn't need to be done July or August, but we think that if things are adequately explained to staff and why the employer is looking to ask people to fill in the form, then there's really very little to spook staff. But certainly if it's felt that it's best to allow the dust to settle and to do it in September, October this year, we can't see that there's going to be any difficulty with that. The other thing, of course, to think about is employees on secondment. Many international businesses will second employees to and from operations as part of building up that necessary shared culture across companies operating in different countries. And clearly those arrangements are going to need to be reviewed post-Brexit to see whether the terms that are being given to people are still appropriate. Talking of auditing, and very much in line with what Mark was saying around the audit, the auditing contracts of employment, particularly for senior management, you need to know whether you've got rights to transfer staff to and from countries, because it's exceedingly unlikely that courts would imply a mobility clause to move an individual from one country to another. You almost certainly need an express power to do that. So we think that's something people should be looking at, and it may well be that you're able to introduce these as part of a pay review, for example, an annual pay round, introduce an express mobility clause to give yourself options if businesses are considering relocating some or all of their operations outside the UK. Sticking with the contract employment theme, we also think that it may be appropriate to look at changing now other terms of contractual documentation affecting employees. Mobility clauses, that's the one I've mentioned already. Giving some thought, how are you going to deal with restrictive covenants if you have an internationally mobile workforce, or a workforce where you need to move people from England to France, to pick a random example? How are you going to deal with restrictive covenants that are going to be enforceable both in England and France? We've done a certain amount of work for clients on that very subject. The other challenge, I think, and it's not been picked up on generally, is the danger that the employment law applying to individuals in the UK is cut back, that the level of protection is reduced. And I know at the moment individual ministers have said, no, we're going to retain European employment laws. I would be surprised if that was the position longer term in all its current glory. It seems to be a bit inconsistent with the bonfire of European red tape approach. But one of the obvious dangers for employers, particularly those who've got expansive staff handbooks or who set out provisions in contracts of employment incorporating or explaining statutory employment law, is that if that statutory employment law is then repealed, but you've put something into a staff handbook or a contract, then you may find you've inadvertently contractualised that documentation so that you have given employees contractual rights to protections that are no longer necessary. And in those circumstances, probably the best thing to do is to make sure that in any audit or any amendment of staff handbook or contract, there's a general provision that explains that you're setting out a summary, or the employer's summary of the law. It's not intended to take away any statutory rights, but nor is it intended to grant any rights over and above the statute or the law itself. The other area we think that employers should be looking at the moment is outsourcing. If companies are entering into lengthy outsourcing contracts now, they're probably doing so on the basis that the transfer of undertakings regulations will apply at the start of the operation and then will apply again on the termination of the contract if it's brought back in-house or if it's second generation outsourcing. And this is very important because it allows everyone to look at how they manage costs. There's an obvious reciprocity. What happens on the way in happens on the way out. If the TUPE regulations were to be cut back, if the service provision change rules were to be amended or repealed, that assumption would no longer necessarily hold good. Now, at first blush, that might be something you think if you're a customer and you're outsourcing, well, great, that's something that my supplier can worry about, it's not my problem. But I don't think it necessarily follows it's quite as clear-cut as that. And so it's something that I think businesses should be thinking about now if they're entering those outsourced contracts. What would they want to happen if it was uncertain whether TUPE would apply at the far end? An employer, the customer, might take the view that it can't outsource, it can't take the business back in-house, or it couldn't pass the business on to a second-generation outsourcer if it was unclear whether the workforce would go with the business. If a skilled workforce is lost, that may preclude such a move. Alternatively, if the pricing for the outsourced contract would allow the supplier to say, well, I have to make these people redundant because I can't transfer them on to the next generation, and I can pass those severance costs back to the employer, the customer, then that sounds like it's the customer's problem after all. So one thing we've been thinking about is it should be possible to construct a contractual framework which would allow parties to effectively contractualise TUPE by setting up a service company and putting employees who were transferring employees or would be transferring employees into a service company, because then you'd always have the opportunity of selling the shares in the service company if the contract was then being passed on to a second generation service provider or indeed taken back in-house. It may be a low risk that TUPE will be fully repealed, but it's certainly not an impossible outcome, and it seems something that would be sensible for companies to guard against. The other thing, just talking about TUPE and saying very briefly, is that there's been a lot of stuff around businesses relocating or offshoring. Point to bear in mind, of course, is if you are looking at that, TUPE will apply to an offshoring, and the fact that a business is going from England to, my hypothetical example, France, or the US, or frankly anywhere else, TUPE will apply because the business starts in the UK, and unless the business has been radically changed by the transfer, that will need to be considered. The other thing, of course, is the planning for this takes a long time. And there may be a difference between making investment decisions to build up an operation in France rather than the UK. But if you're actually looking at transferring jobs, resources, etc., then TUPE is an issue, and it takes extensive planning. So those were our thoughts on Brexit, and I was, in terms of the shared areas. Now, one thing I'm keen to do, though, is Mark, you were looking at and making a number of general points around data protection.
I was going to ask you a question, though, first, Nick, if I can.
Carefully non-scripted question.
So, one thing that we've been struggling with is the reform of trade secrets law in the form of an EU regulation, which has just come into force this year. Now, clearly, that will be law and remain law as a result of Brexit, at least until some decision is made to leave and we don't keep that regulation, if that is the case. But what happens in an employment context? Because presumably employers and employees will be caught by the regulation now. If the law changes when the UK gives up on the regulation, is that a right which disappears from in the relationship between the employer and the employee, or does it just stay even if
the right was only there? Let's assume an employer and employee have a contractual relationship, and then along comes this development in the law to impose a layer of obligations, and the employer and the employee don't, in any sense, contractualize it or issue a staff handbook that refers to employee rights or anything like that, then for so long as the law is there, it applies, and then once it ceases to apply, then in respect of any future developments that might have been caught, you'd assume, wouldn't you, that the law would no longer apply because it's been repealed. What happens whether that retrospectively removes protection for things that were caught when they were caught? Interesting question. Yeah. Yes. Good. Yeah. So we're going to do a question we don't know the answer to, Mark.
That's fine.
Yes.
That's fine.
One to debate. One to keep a careful eye on.
I think so. Yes.
Mark, did you want to say a couple of general points about?
Yes. So I think in the more general intellectual property area, there are a couple of things to bear in mind. First, that in the area of intellectual property, there are some rights which are just EU rights. So we have a community-wide trademark, we have a community-wide design right, and when the UK leaves the European Union, those rights will no longer exist in Europe. And so businesses might be thinking about how they might plan for independent protection of those rights in the UK when the UK is out of the EU. Now, of course, it's quite probable there will be some kind of transitional arrangement allowing those rights to be protected in the UK, but maybe not. It's worth bearing it in mind. And then the other thing that is kind of complete uncertainty is the idea of exhaustion of rights, because if you take the example of somebody who has a trademark, say a trademark for, I don't know, sunglasses, which they put the sunglasses on the market in Italy, and somebody gets hold of those sunglasses and sells them in the UK under the same trademark, but not with the authorization of the brand owner, then the brand owner can't use their trademark rights in the UK to stop that sale, because the original products were put on the market in the EU by or with the consent of the trademark owner, and that's called exhaustion of rights in IP terms. Now, what's not clear is whether the exhaustion of rights principles will continue to apply to sales between the UK and continental Europe post-Brexit. And we may, depending on how currency movements move between the euro and the pound, see the emergence of people buying goods in, say, Northern Ireland and trying to sell them in the Republic of Ireland, and being faced with the possibility that the brand owner will be, for the first time for 40 years, be able to exercise their Republic of Ireland trademark rights against somebody buying cheaper product in Northern Ireland, trying to sell them in Dublin, or maybe the other way around. You can take a bet on which way the pound is going to go against the euro. So that is an interesting area to keep an eye out for. Nothing to do with employment law, though, of course.
But important IP issue nonetheless.
Yeah.
Understand. Good. Okay. Well, thank you, everyone, for listening. Hope that was useful. We enjoyed doing this. In terms of contact, if you do have any questions or so on coming out of this, Mark, what's the easiest way for someone to get in touch with you to ask you those difficult IP questions?
Well, I think you can telephone me, or you can use email. And the email contact details and telephone contact details are on the website. But my email address is mprinsley@mayorbrown.com.
And it's N for Nicholas Robertson at mayorbrown.com. So thank you very much indeed for listening. Our podcast series, the Employment Podcast, is available on iTunes, Mayor Brown Internet, YouTube, and links are posted out on Twitter. Mark, the YouTube series is YouTube, and presumably there are links on the Mayor Brown Internet. And so on. Cool. Okay. Well, in that case, thank you very much, everyone, for listening. We hope that was useful.
Cheerio.
So, that concludes this podcast. We hope that you find it and others in this special Another View series helpful. If you have any comments or questions, please email Nick at nrobertson@mayorbrown.com. This podcast is an overview of the cases and law, and how the law will apply in any particular case will depend on the individual circumstances. Listeners should seek legal advice if any of the matters discussed are relevant to a specific issue or concern. Thanks for listening.